पत्रकार परिषद में बीजेपी पार्टी का नेता के रूप में नहीं आया। ये पत्रकार परिषद राज्यसभा सेक्रेटरीट के द्वारा आयोजित किया गया है। आप सबको मालूम है, गृह मंत्रालय का स्थायी समिति का अध्यक्ष के रूप में स्थायी समिति का रिपोर्ट आज हमने सदन को प्रस्तुत किया है और इसके बाद इस रिपोर्ट को पब्लिक करने के लिए मैं आपका सामने आया हूं। फ्रेंड्स, टुडे आई एम नॉट हियर एज ए बीजेपी लीडर but as the chairman of the standing committee of Parliament on Home Affairs. You are all aware, the chairman of the Rajya Sabha referred Criminal Law Amendment Bill 2012 as introduced on 4th December in the Lok Sabha, and pending therein, he has referred it to the department related standing committee on 28th December. This was referred to us on 28th December for examination and report within 3 months. The committee considered the bill in 8 sittings and adopted the report on 26th February 2013. The committee also took cognizance of the promulgation of the Criminal Law Amendment Ordinance 2013 on 3rd February by the President of India. That means when the matter was under the examination and consideration of the Standing Committee, the Government of India has promulgated an ordinance about the same. The committee considered the bill in the light of the provisions of the ordinance while making its recommendations. There may be confusion in the minds of the people that we are making recommendations on the basis of the ordinance. No. A bill has been referred to our committee. While we were examining the bill, the government has appointed Justice Verma Commission to study this aspect of growing assault on women and the steps to be taken. So that took away some of our time, because we also waited for submission of the report of Justice Verma and also the reference of the same to our committee. So 1 month time has gone in that. We have also issued a public notice to the people at large, requesting them to convey their opinions to the committee so that we can take note of the same. 492 public memoranda were received, and 5 state governments and union territories have also sent their opinion. The committee has examined the representations received from the public, views conveyed by the state governments, and also the recommendations made by Justice Verma Commission and the provisions of the ordinance issued by the Government of India. Friends, the committee has recommended for insertion of several new sections in the bill. Most of the existing provisions of the bill have also been amended. So if you look through the bill, you will not be able to understand it, because the bill has gone a total change practically. I will only read the highlight of the recommendations made by the Standing Committee. A new section 166A proposed to be inserted in the IPC provides punishment to the public servant disobeying the direction under law. The committee has recommended to make the punishment rigorous imprisonment besides making the offence cognizable and non-bailable. Public servant disobeying the directions given to him, he will be punishable with rigorous imprisonment, and also the offence is made cognizable and non-bailable. This is one important recommendation. Second, new section 326A and B make acid attack or attempt to throw acid a specific offence. The committee recommended that the sale of concentrated acid should be regulated and should be sold to the people only on the production of a certificate issued by the competent authority, so as to ensure that it is sold to the genuine end users. This is initiated because of the recent trend of growing tendency of throwing acids on women or fellow students. Large scale reports are coming in. Keeping that in mind, we thought we should regulate the availability of acid. Next, section 354B provides for assault or use of criminal force to women with intent to disrobe. In this section, the punishment provided is not less than 3 years, but which may extend to 7 years with fine. The committee felt that the punishment is not sufficient for the crime and should be increased to 5 years, extendable to 10 years with fine, both fine and punishment for attempt to disrobing of a woman. The new section 370 and 370A seek to deal with trafficking of persons and employing them for exploitation. The committee has recommended that the Ministry of Home Affairs may bring both forced prostitution and induced prostitution under the ambit of exploitation and sexual exploitation. But there, the ordinance has omitted a sentence, word political. The committee is of the view that the word political should continue. That means being in a position of economic or social or political dominance commits sexual assault on a person under such dominance, it becomes an aggravated offence. That is the change the standing committee has made, recommended. The attention of the committee was also drawn to the issue of clemency given by the President of India. You are all aware that the outgoing President has given clemency to 4 people who have been convicted for rape with a death sentence. Unfortunately, clemency was given to them. Taking note of it and discussing it with the Home Ministry officials, the committee noted wherein the accused died well before the clemency was given. In one of the cases, the accused have died, but clemency was given in that instance also. So, the committee felt the application for clemency should not be considered in rape and murder cases.